Please proceed. I think this is an example of where the speaker takes just a little bit too long to get to the podium and be ready to speak. It's nearly half a minute and the bench is waiting.
President Donahue, Your Excellency Nolte, Your Excellency Gomez, may it please the court.
Now, some may not like this, but I like how the speaker addresses each of the judges by name. She does that consistently throughout the presentation, which is something typically done in U.S. appellate practice.
My name is Anastasia Shashkevich, and it is a great privilege to appear on behalf of the Union of Ambrosia, the applicant in today's proceedings. I will assist the present court with Ambrosia's remaining submissions C and D. First, pertaining to Rovinia's unlawful issuance of fishing licenses in the parts of the Triton Shoal that are located within Ambrosia's exclusive economic zone. Secondly, Rovinia's unlawful seizure and sale of the Falcon, based on the Transitional Council's waiver of immunity.
So we see a rather slow pacing, which still could be maybe a little bit more reserved, contain some lengthier pauses between the sentences, but very solid eye contact, and in style, a potentially rather nice contrast to the first applicant in terms of demeanor. That being said, right from the start, the oralist establishes a great connection with the bench. Although the voice might sound a little bit shaky, understandable in these specific circumstances, she still radiates a confident and calm presentation.
Turning directly to submission C, Your Excellencies. The applicant brings the case of paramount significance before the present court to rule on the pressing issues of current international law, pending the decision on advisory opinion in respect of obligations of states in light of climate change.
What is interesting is that there is a little bit of a contrast between the style and the contents of the pleading, because the vibe that the oralist is giving is much more a rather calm and competent appearance, but the wording is actually more dramatic, a case of paramount significance, a pressing issue. I remember sitting in the room and finding a little bit of a disconnect here when the oralist chooses to use the rather big, dramatic words, but chooses not to necessarily sell those words in a style that matches the higher emotional stakes, in a way, of their arguments.
Here, Your Excellencies, the applicant raises two arguments.
So this sounds like a really good, succinct summary of the applicant's submissions on the fixed baselines, but she says that the applicant will raise two arguments. The first, that fixed baselines are encompassed by Article 5 of UNCLOS, but I'm not sure we learn what the second argument is here.
That its fixed baselines are encompassed within Article 5 of UNCLOS as interpreted in line with the rules enshrined in Article 31 of Vienna Convention on the Law of Treaties.
This could be considered a minor issue, but what I was missing here is a direct quote of the treaty provision involved, and a direct reference to the wording, because this serves as the basis, as the foundation to the argument, and might have helped the oralist to establish what the exact point is. And the risk is that if the foundation isn't there, the bench can sometimes struggle to connect with the actual argument. And
Ambrosia in 2015 adopted its freezing law by deciding to fix the location of its low water line as of 1st of November 2015, and later depositing its nautical charts to the UN Secretary General, according to clarification 2 to the Statement of Facts. As such, Your Excellencies, by disregarding these provisions of the applicant's low waterline and normal baseline, Ravinia violates Article 58 of UNCLOS, which requires other states to have due regard to the rights of the coastal state in its exclusive economic zone. Moving to our first argument, Your Excellencies.
So the second applicant says, moving to our first argument, but there's no break between her introduction and that. There needs to be a natural break so the court can follow the flow and realise that, yes, this is going to be a new submission.
Interpretation of Article 5 in line with Article 31 of VCLT encompasses both ambulatory and fixed baselines, as long as it is the coastal state that recognizes them. As such, Your Excellencies, we turn to the finding of ITLOS in its advisory opinion in relation of obligations of states in climate change 2024, where in paragraph 130, it recognized that UNCLOS is a living instrument and shall be interpreted considering the developments of law in light of climate change implications. Your Excellencies.
Could I ask you, please? I'm familiar with what the ITLOS had to say, but could you locate your argument more precisely within the terms of the Vienna Convention on the Law of Treaties, please?
So Judge Donahue asked the speaker to get to the point regarding her interpretation under the Vienna Convention on the Law of Treaties. Sometimes a comment like this can be a little jarring because it cuts you off and instructs you to get to the point. This comment came about, however, because the speaker started with the ITLOS case instead of advancing her treaty interpretation argument under the convention.
A little bit of a strange sounding question. What Madam President more or less hinted at was that, yes, everything that the speaker said was correct, and she found one of the main focal points regarding authorities, which is the advisory opinion by the International Tribunal for the Law of the Sea. What Madam President is lacking here is a connection with the agent's arguments. Where exactly is the agent going with the matter of treaty interpretation? And before this basis isn't established, the bench does not want to hear a thorough analysis of any authority, in fact.
Certainly, President Donahue, here we rely on all elements of Article 31 taken in unity to interpret UNCLOS, specifically Article 5, following from ordinary meaning, the context of the convention in light of object and purpose, as well as increased and subsequent practice of parties to UNCLOS in accepting fixed baselines under the umbrella of UNCLOS.
The speaker summarizes the specific components of her VCLT argument. First, plain language. Second, object and purpose. And third, subsequent practice. I like how she summarizes this, but let's see if she actually follows through with it.
And turning first to the ordinary meaning of Article 5, here we draw this court's attention to the wording, and it is, as I quote, except where otherwise is provided in the convention, the normal baseline for measuring the breadth of the territorial sea is the low water line along the coast, as marked on large-scale charts recognized by the coastal state. Taking in the context of UNCLOS, where there is no obligation upon the states to update their nautical charts, once the state decides to fix the location along the coast, it shall be then respected by other states accordingly.
The speaker correctly starts with the plain language, but when it comes to the object and purpose, she doesn't explain how the lack of an obligation to update the nautical chart is consistent with this object and purpose, which is the second component of her treaty argument, with the third being subsequent practice.
Excuse me, you said that, or you suggested that you would rely on the argument that UNCLOS is a living instrument. The argument that you are putting forward now does not presuppose that UNCLOS is a living instrument. Am I correct?
Judge Nolte is trying to point out a possible inconsistency in the speaker's argument, because earlier she mentioned that UNCLOS was a living instrument. Nolte, however, points out that the argument she's making doesn't comport with that notion. It is important for the speaker to address this concern. Let's see how she handles it.
Your Excellency, Nolte, let us clarify. Indeed, it is a living instrument, since the applicant here concedes that at the time of the drafting of the convention, the parties could have only presumed the baseline to be ambulatory because they did not understand the repercussions of sea level rise and climate change and their possible legal consequences upon the practice.
So, not exactly a direct answer, is it? Not necessarily. However, it can be tricky to understand where the agents stand. And if you take a little bit closer attention to especially Judge Nolte's questions, many of those are yes or no questions. And while it can matter to distinguish your very own argument from the initial yes or no, in many ways, the bench asks the agent to take a stand to see where their argument is located. And if an agent shies away from taking a definite stand, this can be troublesome because the bench loses the connection for the connection to the actual argument.
So you're saying it is only now, after seeing sea level rise, that the parties to UNCLOS finally really understand what UNCLOS means?
Not exactly, Your Excellency Nolte. However, sea level rise indeed induced the change in behavior of states in widening the scope of Article 5 to also indicate fixed baselines and not only ambulatory ones.
The Speaker addresses Judge Nolte's concern pretty well. She explains why her position is still consistent with a living instrument, because the parties have altered their position due to climate change. In the beginning, the understanding of baselines was ambulatory, but climate change forced states to see it as fixed to preserve their maritime entitlements. Thus, her argument is not inconsistent with the notion that UNCLOS is a living instrument. Nicely done.
And here we rely on increasing and evolving subsequent practice of parties to UNCLOS.
Now, this is a tricky strategy because prior, the agent wanted to establish an evolutionary approach under the UNCLOS as a living instrument. But right now, what she actually is saying that there are several groups of states with different opinions. So let's see how this plays out.
There are three groups of states, first of which explicitly adopts fixed baselines for themselves, such as, for example, small island states, Pacific island states, and Polynesian island states. However, there are also states that retain ambulatory baselines for themselves while also recognizing the possibility for other states to fix the baselines under UNCLOS, such as, for example...
So if I understand, then I want to understand whether you're proposing a specific interpretation of this treaty for states that are adversely affected by climate change, or are you suggesting that any state is free to use ambulatory baselines when it's convenient? For example, sometimes we have states where the coastline recedes, and there are other situations where, due to deposition, the coastline moves in the other direction. So please help the court to understand your position on that.
President Donahue, the applicant's position is that the state is its own arbiter of the baseline and indeed may choose to fix it in accordance with UNCLOS. And since the low water line is fixed as a physical feature at the time of depositing the nautical charts, and there is no requirement for subsequent updating of such charts, then they remain permanent and shall be respected by other states.
In response to Judge Donahue's question regarding whether her interpretation is only for adversely affected states, the Speaker takes the position that any state is free to use this fixed baseline approach. However, one should be careful not to take too rigid of a position and possibly think about taking a more reasonable approach. You'll see how she gets further questions from the court because she takes this position.
So again, Madam President asks the agent to take a stance. Is your argument this or that? And in doing so, she offers several examples of potential arguments. What might be helpful now would be for the orators to address these arguments specifically and indicate to the bench how they are aligned with their own argument, or whether they differ. In other words, the agent needs to take a stand and clarify and potentially also address Madam President's specific examples.
So, I'm sorry, I don't know that I understand the answer. Uh, the baseline is fixed as of the deposit always? What about if the state is disadvantaged by the change that occurs between the time of the deposit and some future date? The state is then required to maintain or may freely adjust as it wishes? And how does the rest of the world know about that change?
President Donahue, Your Excellencies, the state may indeed adapt if it uses normal baselines, as in the case of Ambrosia, according to clarification 2. And for other states to be aware of such change, they may refer to the nautical charts submitted in accordance with UNCLOS to the UN Secretary General, which was done by the applicant. Your Excellency, I see.
Here, I'm not sure the speaker with this answer is addressing Judge Donahue's core concern, which is if there's no obligation to update the charts, it seems like having a fixed baseline will disadvantage a state when the nautical charts no longer represent the actual waterline of the state.
Yes, Council, just tell us, would you say that climate change, the consequence of it being sea level rise, has created a fundamental change of circumstance situation? And if so, how would you argue, would you invoke the fundamental change of circumstances in support of your argument, in support of your position? Help us understand it better.
Your Excellency.
And further to that point, would the state of Ambrosia consider itself as a specially affected state?
Your Excellency Gomez, answering your first question, the applicant does not invoke fundamental change of circumstances under Article 62 of Vienna Convention on the Law of Treaties as a ground for termination of a treaty. Here we only deal with unilateral act of determining the normal baseline, and therefore it is inapplicable to the present case.
This was swift, precise, clear, actually an answer that really nicely addressed the question, that avoided getting sidetracked and helped the oralist get back to her initial submission.
As to whether the applicant considers itself to be special affected state, the answer is yes. However, it would be for the purpose of the formation of customary international law, which is the alternative argument of the applicant in respect of the regional practice that has shifted since 2016.
In response to Judge Rubedo's question, which in fact were two questions, the speaker actually handles it pretty well. She answers the first one, and then the second one, and she's able to remember that, so I thought she did a nice job here. Typically, I would teach my students to answer the more recent question first, and then go back to the earlier question. As to the substance, she answers correctly that this is not a change of circumstance under Article 62 of the VCLT, but then in response to the second question, she says that they are a specially affected state. If you recall Judge Donahue's question earlier, she was asking whether the applicant's interpretation depended on them being a specially affected state, and she said no. So here it comes off as a little inconsistent, but she notes that this was part of her alternative argument. This is probably the second point that she was trying to make in her roadmap, but she was only able to identify the first point in that roadmap.
By the way, if you look at the speaker's right hand and the consistent movement, what's interesting is that it actually mirrors her flow in speaking. The bench might not necessarily be able to see the hand moving, so it might neither distract from her pleading nor necessarily support her. My point here is that you see more or less constant movement, and especially for the final round, where the judges are not familiar with the case, as are most of the judges in the prior rounds of the World Championship, it's risky to not include enough pauses, because pauses allow the bench to think. And if you have the constant flow it might seem calm and convincing, and especially for all of the judges who are very familiar with the arguments, also sort of entertaining and engaging. But in this specific setting, maybe more pauses would have helped convey structure to the content, which is very well researched, but apparently doesn't necessarily get to the bench.
Your Excellencies, turning then to a subsequent practice, which is in favor of encompassing fixed baselines under Article 5 of UNCLOS, there is tacit acceptance as underlined in ILC draft conclusions on subsequent agreement and subsequent practice that can be the ground for the agreement among the parties to the convention to indeed progress and read into the wider scope of Article 5.
I understand that you are making the argument that there are a number of states which engage in a practice in your sense, and the rest of the states parties to UNCLOS are silent. Is that the point you are making? And if so, is it really true that all the other states are silent?
Your Excellency noted there is no state except for Romania that would explicitly object to fixed baselines. However, there are indeed parties to UNCLOS which have not yet voiced their opinion. But in the submissions to ILC in respect of their report on sea level rise in relation to international law, a number of states that consider their interests to be affected by these repercussions voiced their opinion in their written statements.
In response to Judge Nolte's question as to the number of states which engage in the practice versus the number of states which have remained silent, what's notably missing here is the actual number of states that are actually in support of this practice. Here, I would have noted the number of states that are in agreement.
Well, if I'm not mistaken, there are states, maybe 2 or 3, who have stated that they reserve their position and that this is a difficult question and one shouldn't jump to conclusions. How would you evaluate this practice? Is that positive practice? Is that negative practice? Is that something in between? And if it is something in between, how should we assess it?
Maybe you see the shift here in the interaction, because for the alternative argument, now the bench understands the point the oralist is bringing forward, and the questions are much more detailed and go more for an in-depth analysis of the argument that the agent brings, which is much different from the discussions prior, where the bench mostly struggled to understand where the argument was going. And finally, Applicant takes a stance and exactly tells the bench where they are headed and what their main point is.
Your Excellency noted, indeed, it is the applicant's position that silence can amount to positive practice in establishment of the agreement between the parties. And since some of the states do not consider probably their legal interests to be affected by including fixed baselines under Article 5, then it is presumed that it now is widened in scope and encompasses such a possibility for the state to proceed.
I don't believe the speaker directly addressed the question posed by Judge Nolte, which is whether a state who has reserved its position can be equated to a state who remains silent. Here, the speaker says that silence is acquiescence, but Nolte is saying that when a state reserves its position, they're not really being silent, so I don't think she answers the question.
Counsel, are you taking, is your state taking the position that the information available to the court regarding subsequent practice establishes the agreement of the parties to the Law of the Sea Convention regarding the interpretation that you're putting forward? That's your position?
President Donahue, in this respect, we admit that the court's interpretation in the present judgment could affect other parties to UNCLOS, and under Article 63, Clause 2 of ICJ statute, the register will notify other parties in respect of the construction of the treaty if they wish to put forward their position in this respect.
Here, the speaker misunderstands Judge Donahue's question. Judge Donahue asked whether it is her government's position that this new practice constitutes a subsequent agreement of the parties regarding the interpretation of unclose. The Speaker, however, interprets it as asking a question regarding the rules on intervention under Article 62 or 63. And you'll see Judge Donahue correcting her on that point with a follow-up question. Again, this underscores the importance of listening to the question.
Sorry if I wasn't clear. I wasn't going to this procedural point, but rather I'm just trying to understand that you take the position based on statements of states, silence of states, and statements by states that they are reserving their position. All of that taken together leads you to conclude that there is agreement of the parties to the law of the sea convention that's consistent with your interpretation. Is that your position?
Yes, President Donahue, it is.
So in your view, silence is the same as a state reserving its position then?
And this is what Judge Donahue wants. She wants a yes or no in order to then ask her actual question. And whenever an oralist gives that to her, she has the conversation that President Donahue wants to be having.
It can be acquiescence to the practice accepted among other parties, in which they either actively engage or do not oppose to it.
Here, the second applicant doesn't really answer the President's question about silence being equivalent to agreement. If there's really nothing she can add, then it's probably a good tactic to move smoothly and swiftly on to the next submission. And that's what she does. But it will have left the President wanting an answer to her question.
Your Excellencies, as such, Ravinia lawfully exercised, Your Excellency, pardon me, Ambrosia's rights were violated by Ravinia by issuing licenses in the parts of the Triton Shoal that lie in exclusive economic zone of the applicant state. Turning then to submission D, Your Excellencies.
The Speaker turns to her fourth submission after spending about 12.5 minutes on her third submission. So there's a little bit of a time problem. It's not bad, but it could be better. As a point of comparison with the first speaker, she is good, but a little more nervous at times than the first speaker. That being said, she maintains great eye contact with the judges, and she is also articulate.
Where Ambrosia puts forward the violation by the respondent of customary international law on immunity of state property. Here, the crux of the matter is whether the Union of Ambrosia agreed to enforcement measures against its sovereign asset, the Falcon. And the answer is in the negative, since at the time only Ms. Zavala, which was the acting president of Ambrosia, could issue a valid waiver of immunity. However, she did not do so in accordance with paragraph 45 to the Statement of Facts, where she transmitted to the Primordial National Court her statement on the fact that the Falcon still enjoyed immunity. In this respect, Your Excellencies, the applicant relies on two arguments, which are alternative in their nature. First is that the customary international law as of today grants governmental status to the entity which enjoys constitutionality, even if lacking effective control. Secondly, if the court agrees with the position of the respondent on the application of effective control legal test, then the Transitional Council still did not satisfy two criteria, namely assertance of permanence and acquiescence of population.
The Speaker provides an excellent roadmap for her fourth submission. She points out that she has two arguments, and she identifies what those are. Nicely done.
Proceeding with the first argument of the applicant on constitutionality. Here, Ambrosia indeed acknowledges that for a long time, effective control over the territory was determinative of the status of an entity under international law as the government.
Excuse me. I wonder about this position of effective control. Don't all parties in Ambrosia agree that the constitutional president of Ambrosia is still the constitutional president and that the constitution continues to govern the situation? Isn't the situation just a sort of a possible simple illegality and not a question of constitutionality?
Your Excellency Nolte, indeed it is undisputable that only Ms. Zavala remained constitutional representative of the state. However, in this respect, the applicant puts forward before this court various violation in respect of customary law on immunity of state property, because by relying on its recognition of the transitional council as the government of Ambrosia, it led to the acceptance of an invalid waiver of the Falcons immunity that the transitional council could not issue. And Your Excellency is here. We may proceed with our argument on the transitional council indeed lacking the effective control if you wish, or proceed with the constitutionality argument.
Judge Nolte asks whether this is a question of legality as opposed to a question of constitutionality, because all parties agree that Judge Derry is still the constitutional president. Here the speaker takes the question as adverse, but I don't think that it is. I actually think it helps her. If the transitional council is illegal, then maybe because of that, the waiver shouldn't be recognized. Because she took the question as adverse, she abandons her constitutionality argument and instead goes with effective control, when I don't think that was the point of the question.
Your Excellencies, turning then to the effective control argument on the transitional council not meeting the requirement of ascertainance of permanence and acquiescence of population. The respondent here relied on, in its memorial, on the test put forward in Tinoco arbitration.
Personally, I'm not a big fan of applicants referring to the respondent memorial because in a way what they tell the bench is saying, oh, we have read it, which is great, which is the thing that's expected from the applicants, but dragging a potential respondent argument from the memorial to the light for the mere sake of saying that this is not a strong argument, this might be incorrect, to me does at least not seem very elegant. Still, in content, it can be something that needs to happen, that should be done. But at least for me personally, I think there is a more elegant way to do it. Simply introducing the respective argument with something along the lines of now respondent may argue here, or respondent might make reference to this specific case, might rely on state practice such as, however, the applicant, and then you can still refute the argument, but let me say, it never risks of sounding petty in a way.
Where William Taft elaborated upon 4 criteria for governmental status under international law. They are the effective control over the territory, acquiescence of population, reason...
Counsel, sorry to interrupt your review of those criteria, but could you speak more specifically about, in this case, the timing? So at what point in the life of the Transitional Council was the waiver made?
Your Excellencies, President Donahue, indeed the Transitional Council issued the waiver only 4 days into its establishment, namely on 17th of March 2023. Well, it was established on 13 March of 2023.
And is that relevant to your argument?
It could be relevant, President Donahue, as it shows that the Transitional Council at the time could not ascertain its overall control over the territory of Ambrosia. However, we admit that the respondent indeed accepted the waiver when waiting for the Transitional Council to reestablish itself in the territory of the state. However, it does not render the applicant's argument futile in respect of lack of permanence.
Bearing in mind the ongoing theme of whether or not the oralist takes a stance when facing questions from President Donahue, here again, if we recall the introduction, it was not a yes or no, it was, it could be relevant, Madam President, however, indicating that yes, but actually no. And then the next ensuing sentence also starts with, however, creating something of a double negation after a potential agreement. So in terms of message conveyed, it remains a little bit unclear still where the applicant actually stands here.
Judge Donahue asked the speaker to speak about the timing of when the waiver was made and whether that was relevant to the argument. She starts strongly by pointing out that it was made 4 days after the transitional government took control, and thus was not enough time to establish such control. However, she minimizes the strength of her argument by saying that it could be relevant. She softened the impact of her point when she really didn't need to.
For 3 reasons. Your Excellencies, the Transitional Council itself named itself as an interim government for Ambrosia, waiting for the awakening of President Duray. Secondly, it operated only for 9 months, issuing its waiver 4 days into establishment, as well as dissolved itself upon the return of the President Duray to Ambrosia in paragraph 56 of the Statement of Facts. As to the acquiescence of population, the Transitional Council could also not enjoy from the habitual obedience of the bulk of population, as evident in paragraphs 47 and 48 to the Statement of Facts, where it is precisely mentioned that opposition has emerged among legal scholars as well as activists that came to protest and were violently suppressed by the police, which was under the Transitional Council.
This comes off as a little weak because, again, she interprets the question as adverse when it actually helps her. She says, despite what my answer is, the council still doesn't have permanence, when she really should have said the 4 days shows that it doesn't have permanence, and then here are additional reasons why it doesn't. Plus, there's no acquiescence. In short, this probably could have been delivered more strongly than it was.
Do you find any relevant jurisprudence of this court, of the International Court of Justice, that you can point us to in support of your case?
President Donahue, in respect of ICJ's, unfortunately, no. However, we may refer to national cases, for example, in Fiji versus Prasad, where the Constitutional Court of Fiji underlined that the passive compliance could not be qualified as the acquiescence of people, considering that white protests were suppressed by the entity and injured and led to violent clashes. And the entity operated only for 7 months in that specific case. And here we also deal with this interim and provisional entity that could not act on behalf of the state in its dealings.
The speaker does a nice job of responding to the question of whether there's any ICJ jurisprudence to support this notion of acquiescence. She answers honestly that she doesn't know of any ICJ cases, but proceeds to cite a national case that has similar facts and can be analogized to the instant situation. Her delivery could have been a little more succinct, but it was still a very good answer.
Your Excellencies, as such, the Transitional Council could not meet the support of the population of Ambrosia, as well as to assert a reasonable prospect of permanence. Your Excellency?
Now, if I understand the Statement of Facts, the agreed facts correctly, Ambrosia was very quickly in a situation where there were only isolated and certain individual acts of protest or resistance. But that is normal. That exists in many states and also in such transitional situations. So what is the purpose of the effective control test if you can dispose of it by pointing to a few people who don't agree?
Your Excellency, note that to compare, for example, in situation in Bangladesh in 2024, no protests have emerged against the entity that came into power. However, here we have violent clashes with police that indicate that there was a widespread repudiation of the Transitional Council from the supporters of Ms. Zavala that still retained her claim to presidency and aimed to regain control of Ambrosia, as can be evident from paragraph 40 to the Statement of Facts.
So a rather general question by Judge Nolte on how the argument works in the bigger picture, having understood the argument and now testing out where it leads ultimately. The agent takes her answer much more narrowly and refers it to an actually strong real-life example that ultimately, however, lacks this connection to Judge Nolte's question dealing with the matter of if we have a general rule and we have exceptions, how do we balance these findings?
The speaker does an excellent job of disagreeing with the premise of Judge Nolte's question. He asks whether a few instances of disagreement would be sufficient to nullify the effective control test. However, she adroitly points out this is more than an isolated instance of disagreement, but rather is indicative of widespread support for Zavala, and then she uses an example to back it up. I probably would have liked a little more detail regarding this Bangladesh example, but I thought the answer was still very good.
And as long as she remained the acting president of Ambrosia, only she could act on behalf of the state in deciding the fate of the Falcon.
What account should we give to the statement by President Derry, which he gave on 24 of May 2024, where he called the seizure and sale of our aircraft illegal?
President Donahue, indeed, it only indicates that President Derry did not adopt or acknowledge the Transitional Council's dealings in international fora, but contested that they could not act on behalf of the Union of Ambrosia in this matter.
Judge Donahue asks what import should be given to President Derry's statement that the seizure of the aircraft was illegal. Again, she unnecessarily interprets the question as adverse when it actually helps her. I would have been stronger here and say that this helps us because the president didn't adopt the actions of the council because it was illegal, and thus the waiver should not be recognized. Again, this underscores the need to truly listen to the question.
Your Excellencies, if you have no further questions, this concludes the applicant's submissions. Thank you. May it please the court.
Thank you.
We have seen an oralist who knows her law, knows the facts very well, but at some moments throughout the pleading faced a bench that could not necessarily follow her. In hindsight, what might have helped her dealing with this bench in particular would have been to narrow down her pleading and especially add introductions that highlight quite clearly what the essential argument is, what the main point is that the applicant wants to make here. The oralist carefully established the legal background in many intricacies at times, but in following her there, the bench might have lost at times a feeling for what, and not a feeling, an understanding of what the actual argument by the applicant is.
This is at 47:30 at the end of the second applicant's presentation. Overall, the second applicant has done a really good job. Very articulate, succinct submissions, not thrown by questions from the bench, and of course, excellent content in her submissions, as you'd expect from a grand finalist. The only thing I change is maybe to vary the tone and pace a little, add pauses between submissions. These things just make it easier to follow the argument and make the whole presentation more engaging.